Welcome to Vampire Divorce with attorney Clarke Young.
Hey everybody, welcome into an all-new episode of Vampire Divorce with attorney Clarke Young. I am your host, Mike Leon. Clarke here is a seasoned family law attorney. He's got decades of experience handling high-conflict custody disputes. And in today's episode, we're going to be talking about how to make invisible behavior visible to the court so the record reflects what really happens outside the courtroom. Clarke is going to explain it all in just a second. Clarke, it's good to see you as always. Let me start with a high-level question here for you, which is, what kind of incidents should parents record, and track if they want a judge to take notice?
Oh, well, first, Mike, thanks for having me. The idea of bringing the invisible to the visible and making the court aware of what's going on outside the courtroom is absolutely essential in any case, but in borderline cases, it's quite a challenge, and it's very labor intensive, and it's going to take repeated attempts to get the court to actually accept that what the normal range parent is alleging is actually descriptive and not just an unfriendly parent, which is what they're called in California, someone who appears to be somewhat hostile or derogatory towards the other parent. It begins even before the case. Sometimes I'll come into a case that's been ongoing for several years, and I have to sort of start at the beginning. But if I am in a case on the very front end, they call me before they've actually separated. There's a whole process that goes into that. But the number one element, to answer your question initially, is that I have my clients do what I call a day in the life declaration. Declarations are sometimes called affidavits in a lot of states. But that day in life declaration is going to be the touchstone document that I'm going to come back to and refer to repeatedly over the course of the entire custody proceeding. And it's going to be broken down into about 5 parts. And if you like, I can go into more detail about that. But aside from that first document, which is sort of the Bible, if you will, that you're going to use going forward, and you're always going to refer back to it at every hearing, because you want to remind the judge basically, did you read that? Did you understand it? Do you understand what it means? And then as you go down the pike, if you will, parents outside of the courtroom are going to have to be documenting all kinds of things. And again, we can go into more detail about what those specific things are, but they generally take the form of a diary or a log that the parent will keep track of, where they're noting when they're with the child, what they do when with their child, and how involved they are as a party. The reason for that is that 80% of borderlines are women, 20% are men. So I do get some cases where I'm representing women. Mostly I'm representing men, and unfortunately there are some stereotypes that come into play that you're not really litigating against reality. In reality, you're in a Twilight Zone episode where you are trying to deal with the stereotypes that society has about borderlines and men and women. They actually don't have any stereotypes about borderlines per se, but that's another area that we can get into if you like.
Yeah. Well, let me stay on the journal part of this. So you mentioned the journal and keeping the journal. What about emails, school records, outside witnesses? What else do they need to potentially back up evidence-wise, or is the journal just enough?
Well, the two most important words in the family court system are admissible evidence. Nothing else matters. If you can't prove something, it didn't happen. So in law school years ago, I had a professor who once said that the truth is what the judge decides it is. So it may or may not match reality, and it's your job to bring that reality in a convincing way to the judge. So that journal or that diary or that calendar that you're keeping, ideally, and going back to that day in the life declaration, in the ideal situation, you would be documenting every single statement you said with an exhibit. And that exhibit could be a text message, it could be emails, it could be social media, it could be documents or phone records or bank records, whatever it is. But you've got to keep all those records uh, from the get-go. And as an aside, um, again, if a client comes to me and they're not separated yet, the first thing I want to do is save them about $100,000 in unnecessary formal discovery requests. Because once these cases get filed, they go nuclear, and you are going to have to pull teeth to get any information. So you want to help your client pull together all of the evidence, whether it's support related, property division related, custody related, attorney's fees related, whatever. You want them to document that, and you want to have that ready to go before you even file either the petition for paternity, the domestic violence restraining order action, or the petition for dissolution of marriage. That's what they're called in California, but basically a divorce.
Yeah. Clarke, let me ask you about you gave the analogy about what the your law professor said about the judge and what the evidence the judge finds, right? So what separates evidence in that case from something that shines a light on the truth versus evidence that will just muddy the water?
That's a great question. Um, it is the um, God-given embedded programming of a borderline to make sure that the truth never comes to light. So lots of times in these cases, what you're dealing with is just this incredible high level of deceit, partly because borderlines actually believe that their perception of reality is the only reality. And if that perception changes in 10 minutes, which it often does, the borderlines expect the entire universe and reality should shift to comport with their needs, their desires, their wants, and their demands in the moment. And you can imagine how challenging that is, because anybody can tell a lie. It doesn't cost anything to tell a lie, but it costs about 100 times whatever that lie in damages is causing, or injury and insult that's causing, to actually prove it's a lie. So the difference between those two levels of evidence is just night and day. I don't want to paint this as a black and white situation, but it kind of is. I'm trying to expose the truth, because the only way I can save a child who is embroiled in a child custody proceeding involving a borderline is going to be if the truth is revealed. And that truth is quite shocking, usually. I mean, it's just, you can't believe these people exist, actually, but they have spent their entire lives presenting to the world that they're these perfect people. And so you have to take the mask off. And the longer that mask has been on, the more skin you're going to pull off of their face when you try to expose who they really are.
Yeah. Clarke, let me ask you, and because in a previous episode we talked about professionals that get introduced, as eyewitnesses or things like that, testimony wise. What are some of those professions, or which professionals, like therapists, whether it be custody evaluators, parenting coordinators, are the most useful that you found in these cases, and how do you make sure that they understand what's going on with the case?
Another great question. There is the theoretical, and then there's the practical part of that answer. In theory, it would be wonderful if we lived in a world where there were a lot of psychotherapists and PhDs in psychology who understood borderline personality disorder and family dynamics and a lot of other aspects that are related to borderline personality disorder, and were able to do their child custody evaluations in a way that they could actually educate the court about what borderline personality disorder is, why these parents tend to be the anti-parents, if you will, and what sort of structure needs to be in place so that the child is protected from the borderline aspect of the parent, but still has the parent involved in the child's life. So that's the goal, if you will. In practice, what happens is that with respect to psychologists, in Southern California, there used to be a number of people who have now retired that were actually excellent at and courageous enough to call a spade. But most of them have retired, and they're not being replaced by people who are competent, partly because the California educational system has collapsed so badly that people are graduating college with high school diplomas practically. It's just shameful what's happened out here, and I guess it's happening in other parts of the country too. But it's producing professionals who are not professionals. So as a practical matter, it's hard to find a good child custody evaluator who knows what they're doing professionally. Secondly, as I mentioned before, these people have to have the courage to speak up, because I've gotten phone calls over the years from psychologists who are doing child custody evaluations in other states. And I've had them crying on the phone saying, I'm afraid to diagnose. I've been ordered to diagnose, and if a diagnosis is appropriate, to diagnose in my child custody evaluation, which has a psychological evaluation aspect. So there's two parts to it, the child custody recommendations and then also the psychological evaluation. And they're afraid to diagnose because they know the borderline will go after their licenses, and it's a trauma for them. But that's a topic for another day. As far as other people involved, other than the child custody evaluator, you're going to have, for example, forensic accountants doing property division issues. You might have real estate appraisers involved on property issues and property division. But in the child custody proceeding arena specifically, you'll probably have one or more expert witnesses, and they're going to be percipient expert witnesses because they might be, for example, a professional that the couple went to for couples counseling, or it might be a child's therapist who's been with the child for a while, but who doesn't want to get involved in any way in the case. And so you have to do by cajole or by compelling them, you've got to get people enrolled in helping this child, and not just, I don't know, take people's money and sit there and nod as the child is telling them all the child's problems. So I guess a major theme here is that in general, I have learned the hard way over the years that too many cooks in the kitchen are a problem. You have to be very, very selective on who gets involved in the case. And, again, if you want to get into it, we can. But, when you're trying to get a judge to appoint an appropriate expert, that's a expertise there that a lot of people don't have. And that's an important decision. So, and I think that's, I'll end with that. But those are the key players. I mean, you're going to have a lot of professional experts that way. Then you're going to have people that are pseudo experts, and I just finished a case last year where the other party named 21 school district personnel as expert witnesses. And by the time we got to the trial, only 6 of them testified, and 4 of them stated on the record they weren't experts in any way. And it was just a big, excuse my French, but a circus. We'll use that word. Right. And it's just one of those things. But you'll get all that gamesmanship, but you have to deal with those kinds of obstacles, which are again why these cases cost so much, because you're deposing or cross-examining on the stand people who shouldn't even be there.
Right. Clarke, let me ask you on that front. What kind of orders or rulings show that the judge in this instance understands the reality of a borderline?
Well, again, we're back to the ideal. I'll describe the ideal order, and then it'll be easy to describe how short judges fall in this category. So the ideal order has to, let's say a normal custody order with normal range parents would normally be 7 or 8 pages long. So for a borderline, that same order would have to be magnified and lengthened to probably a 35 or 45 page order. Why? because borderlines don't respect courts, they don't respect orders, they don't respect anybody, and they know they're right. And if the judge enters an order that isn't in their favor, well, they just know there's been a terrible miscarriage of justice, and it's their duty to try and circumvent that order. Therefore, the order has to imagine all the possible permutations that could happen if you only give a general order in which the normal range parent would understand the spirit of the order and comply with the letter and not try and circumvent it. They wouldn't dare. But the borderline sees it as a challenge. And so they will basically tell the judge in so many words, ha ha ha, you didn't write a very good order because you didn't fill in this particular possibility. You didn't see this. And I'm smarter than you and everybody else, and I am going to, I'll do what I want anyway. So if the order isn't written properly, you end up going back to court, litigating the same issues over and over again, which again runs up the costs. How do you get a judge to actually sign that order? And the answer is you can't. I have written very lengthy orders. I don't think the judge ever read them. And then they came up with their own little boilerplate thing that's just a joke. And you end up going back again and again. Finally, the judge will do something that will hold the borderline accountable and fence them in. And again, we could spend a whole episode on just going through what you need to have in those orders. And I could give you war stories on that, but I think that's probably something for another day.
Yeah. So Clarke, as we wrap on this episode, if the judge still doesn't, let's use this term, see the vampire, what are the next steps in that instance?
The next steps are you keep going back in again and again. So when I get a call from a potential new client in California, given the local rates that attorneys charge and what the reality in here and with the court system, I tell them up front that they're going to be spending between $12,000 and $15,000 a month for about 18 months until the judge gets educated, because judges will not, they just will not get into the psychological trauma and the psychological details that they need to in order to understand these cases. And that's why that day in the life declaration that I've been referring to is so important, because I'm going to go back at hearing 2 and 5 and 7 over a year and a half, and I'm going to say to the judge, I want you to go back and read that day in the life declaration and see if you think that your view of what was said has gone from being just causative and caustic and mean-spirited to just being descriptive and matter of fact. And that's when you finally get the judge to move. And the second major pointer here, practice pointer, is that you have to get the judge to understand that the conflict is not between my client and the other party. The conflict is between the other party and the court. Because when the client, that person comes in, when the borderline comes in and says, haha, we're in here again because you didn't write a very good order, you've already made that conflict between the judge. You're pointing out to the judge all the time, she doesn't respect you. She's not going to listen to you. This is what the marriage was like. Do you get it yet? Do you get it yet? And you just keep pounding certain themes over and over again until the judge remembers your case, because they have 200 cases or more at any given point in time, and they don't remember what happened one day or the next, let alone 3 months later. So it's a constant battle. And honestly, of all the players that end up playing in this sandbox, the buck stops with the judges, but the judges are also the weakest link.
Right. Clarke, well said. Thank you for the time and insights on today's episode, Clarke. I truly appreciate it, as always.
Thanks for having me.
And that's it for today's episode of Vampire Divorce. If you want to reach out to Clarke, connect with him and the team, do me a favor, visit clarkeyoung.com. Don't forget to like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.